Would you believe that 144 scholars have written a letter saying that if President Trump's lawyers even raise any First Amendment defense, they will be engaging in unethical, unprofessional conduct because they say that any First Amendment defense would be legally frivolous? Nonsense. The opposite is true. Failure to raise a First Amendment argument in the Senate, that would be disciplinary conduct worthy, because that would deny the client and the American people the benefits of the adversary system and the benefits of zealous representation. You'll hear why on the Dershow. The Trump legal defense team has just filed its brief in front of the United States Senate for the trial that's scheduled to begin tomorrow. And according to 144 people who call themselves constitutional scholars, the lawyers who filed this brief have engaged in unprofessional and unethical conduct that subjects them to possible discipline, even disbarment. Let me explain. Just the other day, these 144 scholars, constitutional scholars, issued a joint letter in which they said that anyone who raises, here I'll read it, any First Amendment defense raised by President Trump's attorneys would be legally frivolous. Now, those of you who aren't lawyers may not understand that legally frivolous is a term of art. Legally frivolous means the argument cannot be made ethically. If you offer a legally frivolous argument, you are subjecting yourself to discipline and possible disbarment. So let's understand what these 144 constitutional scholars are saying. They're saying that the two eminent lawyers who filed the brief today, and if I had been on the defense team, I would have filed a brief in which I made the argument relating to the First Amendment. They have subjected themselves to disciplinary action because the argument is legally frivolous. Now, what was the purpose of these 144 lawyers using the term legally frivolous? They could have just said it was wrong. In fact, in their letter, they say not all of them even agree with that. Some of them think the First Amendment argument may be valid. Others do not. How could it then be legally frivolous? Well, the purpose of putting in the term legally frivolous was to scare the lawyers away, was to send a message to the lawyers saying, how dare you? If you even dare to raise a First Amendment argument, you will be subjecting yourself to discipline. It was an attempt to chill advocacy, an attempt to influence the adversarial process by persuading decent lawyers that they couldn't make an argument that's a completely valid and constitutionally permissible argument. The purpose was twofold. In addition to saying that, quote, any First Amendment defense raised by President Trump's lawyers would be legally frivolous, they go further and they say that, quote, no reasonable scholar or jurist would offer these arguments. Now, that sentence is directed at me. I am a scholar and a jurist. 50 years at Harvard, I think, entitles me to use that term. Publishing 47 books, litigating some of the most important First Amendment cases in the last half a century. I think it qualifies me as a scholar and a jurist. And they're telling me that I am not a reasonable scholar or jurist for raising First Amendment issues. Well, frankly, I couldn't care less what these 144 people think of whether I'm a reasonable jurist or scholar. I am. My arguments have prevailed. My arguments are sound, and I'm going to continue to make them. But who is the target of that statement? No reasonable scholar or jurist. It's young lawyers, young potential law professors who have to go in front of hiring committees. Hiring committees don't hire and don't promote scholars and jurists who are not reasonable. So these 144 so-called constitutional scholars are sending a message to young lawyers. Don't make Dershowitz's argument. Don't make the argument that the lawyers are going to make in front of the Senate. If you do, we have declared you not to be a reasonable scholar and jurist. Again, the effort is to chill free speech. The effort is to chill the adversarial system. Yeah, I think there may be some unethical conduct involved here, but it's not on the part of lawyers who make reasonable arguments about the First Amendment. The ethical question is raised by why 144 so-called constitutional scholars would sign a petition basically trying to discourage, frightening, scaring, threatening lawyers with disciplinary action and disbarment, threatening potential law professors with not being hired or not being promoted if they make an argument that these 144 scholars know is a plausible argument. They may disagree with it. They may think it's wrong. But to say that it's unethical, let me turn it on its head. It would be unethical for any lawyer not to raise the First Amendment issue in front of the Senate. That would be malpractice. That would be unethical. That would violate the rules of professional responsibility. The rules require zealous advocacy, that you make all plausible, reasonable arguments that you believe are true. I know the First Amendment. I was a law clerk with New York Times versus Sullivan. I participated in the case of the Pentagon Papers. I am consulting on the WikiLeaks case. I have litigated some of the most important cases involving the First Amendment, the Harry Reams case, the I Am Curious Yellow case, the Titicut Follies case, the Chicago 7 case. You name it. If you make a list of the 25 most important First Amendment cases of the last half century, I'm in a lot of them. And so I'm no slouch when it comes to the First Amendment. And I'm a winning lawyer. I win my cases. So don't tell me as a lawyer that I can't raise that issue. I'm telling you as a lawyer that if you refuse to raise that issue, you would be engaging in malpractice. You would not be zealously representing your client. And it's shocking to me because this is, again, another form of modern McCarthyism. An attempt to scare lawyers away from making an argument that's plausible. After all, the First Amendment says Congress. It doesn't say the states. It doesn't say the president. It says Congress shall make no law abridging the freedom of speech. And the courts have interpreted no law to mean no action, nothing. You can't take an administrative action. You can't take legislative actions. You can't do anything that abridges the freedom of speech. So on its face, obviously the First Amendment governs. Now, some people say, no. Impeachment's not a legal proceeding. Congress can do whatever it wants. So what about the following hypothetical? What if a Muslim got elected to be president of the United States? Could happen. Would be a good thing for diversity if a qualified person ran who happened to be of the Muslim faith. But what if a bunch of bigots in the House decided to impeach him on the ground that he was a Muslim? The people who say the First Amendment doesn't apply would also have to say the prohibition on religious tests in the Constitution doesn't apply because it's political. It's not legal. They're not bound by the rest of the Constitution. That would be absurd. I don't think any reasonable scholar would ever say you can impeach somebody because they're a Muslim, or you can impeach somebody because they're black, or you can impeach somebody because they're Jewish. That was plausible, by the way, to impeach somebody because they're Jewish, because they were Catholic. Early on in our history, the bigotry, particularly against Catholics, was so great. Thomas Jefferson, John Adams engaged in it, wrote letters to each other saying, wouldn't it be better if no Jesuits were allowed to come on our shores because there's never been liberty in a country dominated by Jesuits. Basic anti-Catholic bigotry that was very prevalent in the early colonies. And we created a constitutional right not to be discriminated against on the basis of religion. But these folks who say that the constitutional prohibition against abridging speech doesn't apply to impeachment would have to also say that other parts of the Constitution don't apply to impeachment. The Bill of Attainder Clause doesn't apply to impeachment. Well, it doesn't apply if impeachment is proper. If it's not proper, then it becomes a Bill of Attainder, putting on trial a citizen of the United States who's not holding office and punishing them by saying they can never run for any other office. These are plausible arguments. These arguments will prevail, by the way. They will win probably in the United States Senate. But these scholars are saying, even if they're plausible arguments, even if they're winning arguments, don't make them. Because if you make them, you will be guilty of one of the worst sins that lawyers can be guilty of, making legally frivolous arguments. So shame on you, 144 scholars, some of whom are my friends, some of whom I admire. How did you do this? How did you let your good name be attached to so McCarthyite a brief? How could these decent lawyers have signed a letter that is designed to frighten lawyers away, to scare them away from making not only plausible arguments, but solid arguments, arguments that they were obliged to make? When your client says to you, I want to raise the First Amendment, and the First Amendment is right there in the Constitution, Congress shall make no law abridging the freedom of speech, you got to raise it. Even if you personally may not agree with it. I personally agree with it. I wouldn't have had any hesitation making the argument that the speech itself was covered by Brandenburg. After all, Clarence Brandenburg, the man who made the speech that was unanimously 9-0 approved by the United States Supreme Court, was a member of the Ku Klux Klan, a neo-Nazi. He stood in front of a large crowd of people who had crosses and hoods and guns and urged them to send the Jews back to Israel and the blacks back to Africa and to march on the Capitol, and we will take revengeance. Revengeance! That was the word used by Clarence Brandenburg. Supreme Court had no problem, 9-0. But these 144 scholars probably would have said, don't even raise that argument, Brandenburg. Don't bother to raise the argument. It's legally frivolous. Winning 9-0, okay, but it's legally frivolous. I challenge anyone who signed that benighted letter to come on this show and defend yourself. Come on this show and explain why you think that I have engaged in unethical conduct by urging lawyers to make that argument. And let me tell you right now, I will represent any lawyer who offers a First Amendment argument to the Senate and is disciplined and is charged with having made unethical, legally frivolous arguments. And I will also support any scholar, any professor, any junior professor who's not promoted or who's not hired because somebody says, quote, no reasonable scholar or jurist would offer a First Amendment argument in the context of this impeachment trial. This is how far we've gone. This is how far we've come. When reasonable men and women, and I know these people, they are reasonable men and women. I like them, some of them, not all of them. Some of them are phonies and hypocrites and just sign the letter or whatever it is, as long as it's anti-Trump. They would sign the opposite letter if the shoe were on the other foot. We all know that, and they know that. But some of them are decent people, and some of them are real experts on the First Amendment. How can you say that it is legally frivolous to argue that the First Amendment covers a speech in which people are urged to go to the Capitol peacefully and patriotically? Peacefully and patriotically. Did anyone hear Brandenburg ever say peacefully and patriotically? No, he said revengeance. And Brandenburg was 9-0. And so it's completely clear to me, 100%, not 99%, 100% clear to me that the First Amendment argument raised in the context of impeachment is not legally frivolous. And lawyers for the president and anyone else, take it to the bank. Tell anybody you want that an expert in legal ethics, Professor Alan Dershowitz, who taught legal ethics at Harvard for 25 years, has written law review articles on legal ethics, is giving you a legal opinion, a legal ethics opinion that not only may you, not only should you, but you must make the First Amendment argument in front of the United States Senate. And if you don't, that will be essentially legally frivolous not to have made that argument. And this is how far we've come. This is what the American legal profession looks like today. It's a shame. The only reason that I'm sorry that I left Harvard 6 years ago, retired when I was 75 years old, I'd love to be back in the battle. I'd love to look Professor Tribe and Professor Freed and some of the other, Professor Minow, and some of the other professors in the eye and say, justify to me why you think that I would be disbarred and disciplined if I dared to go in front of the United States Senate and argue that the First Amendment is applicable to President Trump's speech, and, separate argument, that a president can't be impeached for making a speech that is protected by the First Amendment. But even putting aside the second argument, the first argument, this says that to make any argument, any First Amendment defense, which means that even if you just argue that the speech itself was protected by the First Amendment, that would be legally frivolous. That's right, not legally frivolous. There's a big difference between being legally frivolous and right. You can say it wasn't legally frivolous, it was wrong, but in this case it would be right. And as I said, I view it as compulsory. The rules of professional responsibility require you to put forward every argument your client wants you to make, which is plausible, lawful, based on the law, based on the facts. Just read Brandenburg, and you will see that any lawyer who failed to put forward a First Amendment defense would not be satisfying his obligation of zealous advocacy toward his client. So what is going on? Please, any of you who wrote this letter, who signed this letter, call me, call the show, make your argument, justify it, explain it, come on the show. Those of you who are listeners, call in, tell me why I'm wrong. I'm not wrong. I'm right. The 144 constitutional scholars are wrong. You know, it's interesting. I've often been in a situation where every major scholar has been against me, and I stand proudly by my own views. And I'm never going to be influenced by the crowd. I'm never going to be influenced by the mob. I'm never going to be influenced by academic hiring committees. Yeah, sure, I had tenure, so they couldn't do anything about it. But if I had been up for tenure, I would have made this argument. I wouldn't have been cowed. Why do I want to be a professor at a school that wouldn't allow me to make these arguments and would deem these arguments no reasonable scholar or jurist would make them? So call me. Let me hear your views. This letter gets me angry, and I would love to hear whether it gets you angry, and I'd love to hear what we can do in response. In the meantime, the argument will be made in front of the Senate. I hope that the lawyers are not intimidated or cowed or frightened. They will make that argument, and I think there will be many senators who will accept that argument. Let's wait and see. All week this week, we will see the impeachment trial going on in the Senate, and we will have a lot to say about it. So keep listening, keep watching The Dershow on Rumble, on YouTube, on all the platforms, and keep calling in. I want to hear the wits. I want to hear your voice, the wits that completes The Dershow. Let's turn now to our first question.
This is Bob from New Hampshire. I briefly would like to hear your comments on the recent Time magazine article on how the election was saved. It reads like almost like a right-wing conspiracy theory, but then it also could be construed as the left telling about how they gamed the system and bragging about how they got away with it. Just like to hear your thoughts on that. Thank you.
Well, you know, everybody says that newspaper reports and media reports are the first draft of history. We will see a lot of comments on this election, ranging from the My Pillow man who put out a video purporting to prove that the whole election was a fraud. You know, he has a right to do that. It's an issue that people care about. They may be wrong, but they care about it. Time magazine has its twist on the story. MSNBC and CNN and the New York Times have pronounced their views on the issue. People who watch the show have different views on this. That's why we need a voter integrity panel. We need a definitive group of objective, neutral people who can look at every single election. We have that in some other countries. In fact, American monitors are often sent to other countries to monitor their elections. We need our own monitors. So I hope a VIP panel can be set up in the future. And I have no objection to setting it up for now, too. Let's get objective analysis. Let's call the pillow guy in. Let's call the Time editors in. Let them present their evidence. There are lawsuits now going to be going forward. We saw that already. Some media people have lost their jobs over making these arguments. Marketplace of ideas is wide open. Let's keep it open, and let's keep an open mind.
This is John Romano. Although I disagree with Marjorie Greene, and the Constitution says they should make no law abridging freedom of speech, isn't it true that the Congress is self-regulating and self-policing? So they're actually not making any law abridging that constitutional freedom of speech, but in fact disciplining within themselves. Thank you. Please comment.
It's a very, very good question. It goes back to what I said a little earlier. Yes, Congress is self-regulating, but it has to abide by the Constitution. I can easily imagine back in the bad old days, Congress saying they didn't want any African Americans. They didn't want any former slaves. That would be unconstitutional. The 13th, 14th, and 15th Amendments would preclude that. But if Congress is self-regulating, they would be able to ignore the 13th, 14th, and 15th Amendments. I don't think they can. And when the First Amendment says Congress shall make no law abridging the freedom of speech, it's been interpreted by the Supreme Court and by other courts to go beyond law, to include administrative action. So I believe Congress is bound by the rest of the Constitution in every decision it makes, including disciplining of its own members. Remember also, there's a provision in the Constitution that doesn't permit members of Congress to be questioned anywhere else for statements they make on the floor of Congress. Of course, Greene was being disciplined for statements she made before she was a member of Congress. That's a knife that cuts both ways. It gives Congress essentially less power because they are not governing one of their own members. They're governing a private citizen who made statements as a private citizen. But it also doesn't apply the speech and debate clause. So very interesting and very difficult questions. Next question.
Thank you for your show, Professor Dershowitz. I really enjoy it. I'm a volunteer for the Convention of States Action, which is an initiative that aims to take advantage of Article 5 of the U.S. Constitution. You can learn more about this initiative at the conventionofstates.com. My question is whether Congress could find a way to block a properly called Convention of States. Thank you.
I don't think so. I think there are various ways of amending the Constitution, and there's broad discretion in the Constitution. Congress has one way of doing it, but I think that there are other ways as well. And so just, stick to the letter of the Constitution, the letter of the law. We are a nation under laws. We operate under the rule of law. The rule of law is in great jeopardy today. Today, the rule of politics, the rule of partisanship, seems to be governing our country in every respect. Scholars of the Constitution are prepared to twist, turn, distort, destroy, ignore constitutional provisions. We went through a golden age of constitutional law. I'm proud to have been part of it. The golden age really started in about 1960, my second year in law school, and probably ended at the turn of the 21st century. It was a 40-year golden age in which some of the most important decisions about freedom of speech, about civil liberties, about human rights came out of the courts, and in which Americans seemed to, whether you were Republican or Democrat, seemed to support the Constitution. In the last 20 years, we've seen a strong diminution of the rule of law, and particularly in the last 4 years. I have a new book coming out about that issue, should be out in a month or so, which deals with what's happened over the past 4 years to our constitutional rights. Once the book's out, I'll talk about that a little on the show as well. But all of your questions seem to be directed at that same point. Are we still a nation under law, or have we become a nation under partisanship? Let's hope we can preserve the rule of law. Let's hope we can follow Benjamin Franklin. It's a republic if we can keep it. We're losing it. and we have to restore it. I think we can restore it. I think we can return to a situation where Americans agree about the outcome of elections, where Americans agree about the importance of the First Amendment. And the one thing I want all Americans to agree to is please watch and listen to the Dershow, where you'll always hear a straight analysis of constitutional law, politics, and the news. Looking forward to seeing you and hearing you again tomorrow. An important part of the Dershow is your voice, your questions, your comments. Please call 24/7. The number is 216-710-0050. Keep your comments short and to the point. Again, the number for you to call 24/7 is 216-710-0050. Hard questions, criticisms, everything's fine. Just keep your questions short, and I'll answer them all on the Dershow.